and their role in the criminal trial. So they're really an important part of criminal justice. They have this role of being the fact finder in any trial they sit on. In our Constitution, Article 3, Section 2 mentions that there's a criminal right for jury trials. So for a little while there was only a criminal right for jury trials. But the Sixth Amendment again specifies we have the right to a jury, but all it says is you have the right to a jury trial. So there wasn't a lot of detail. It doesn't say whether juries need to be unanimous, how many people can sit on a jury, or anything like that. So over 200-ish years and up till now, we have seen a lot of cases kind of litigating out the parameters of what it means to have a Sixth Amendment right to a jury. So when we have a jury sitting in the courtroom, they have this says almost unlimited direction. That's a typo. It should say almost unlimited discretion. Juries are the fact finders. So they, based on what's presented to them in court, and keep in mind they're not getting everything. They're only getting what's admissible. They get to decide whether or not they believe it and who to believe. And there's not really any parameters on them. So if a jury finds a witness to not be credible, they can discount the entirety of the testimony. If they find a scientific test that they don't agree with, they don't have to use that expert testimony's the expert witness's testimony at all. So they have a ton of discretion about what they choose to use as the foundation for their decision and what they ignore. Now, one limit on that is the defendant's Fifth Amendment rights. The defendant has a constitutional right to not testify, and if they elect that, the jury cannot consider that in their decision. They are not allowed to hold the failure to testify against a criminal defendant. Okay. Additionally, jurors are not supposed to consider the defendant's possible punishments. They are supposed to decide what the facts of the case are. It's not their job to worry about the sentence, either not convict because of a sentence or nullify. They are not supposed to do that. Jurors, after the case is over, will receive written jury instructions. They will be delivered jury instructions in court. They will also receive a set of written jury instructions. In a lot of trials, these are 12-ish pages. A lot of it kind of defines their roles and responsibilities as jurors, and then there's the second half of it details out the specific crimes that this defendant is charged with and kind of lays out the prosecutor's duties. Okay. So, limits on right to trial by jury. Originally, the Bill of Rights was, we've talked about this multiple times before, but only applied to the federal government. So for a period of time, up until the 1960s, your right to a jury trial only applied if you were in federal court. So state courts could, in their own state constitution, guarantee a right to a jury trial, but they did not have to. In the 1960s, the right to a jury trial was expanded to states. Now, you don't have to have a jury trial for like a petty offense, but anything else you are entitled to have a jury. So when you get a jury, the size of the jury depends on where you are. The Sixth Amendment doesn't tell us how big a jury should be. Rule 23B, the criminal rule, says that 12 members is required at the federal level. Now, it has been litigated out that 6 is the fewest number of jurors permissible. Now, for felonies, most states do not use 6-person juries. For misdemeanors, about 35 states do use 6-person juries, 6 or 8-person juries. So we're in this country much more likely to use a smaller jury for a less serious offense. By and large, when it comes to a felony case, we almost always use a 12-person jury. Now, Unanimous verdicts are not required. So juries, there's not a requirement that juries have to return a unanimous verdict unless it's a 6-person jury. 6-person juries do have to be unanimous because they're smaller. Now, most states have taken the step of requiring a unanimous jury verdict in their own state, but there are some states that accept divided jury verdicts. So, and I think Oregon is one and Louisiana is one. A 10-2 jury verdict would be acceptable there for conviction. Now, unanimous verdicts are the traditional standard. It's the most common standard, but again, it's not a mandate under the Constitution. And the thought is that it's more legitimate if everyone on the jury agrees and minority jurors are able to speak out more. It protects their voice when they dissent based on their own experience, that it recognizes and preserves that. Now, before we move on, the requirement of unanimous jury verdicts might receive some clarity. There is a case sitting on the Supreme Court's docket right now, and the question focuses on whether or not having a non-unanimous jury verdict violates a defendant's Sixth Amendment rights. So we might see the Supreme Court in the next, sometime between now and June, issue a ruling that does mandate unanimous verdicts. And so if they do so, that would be the law across the country moving forward. Okay? Now, next kind of few slides are dealing with the ways that we actually get jurors. So our goals when we select jurors are to get a fair cross-section of the community. The idea is that if we get a little bit of everyone who's in our community and pool them on our jury, that we're going to get some jurors who can relate to the defendant, and that we can also get unbiased jurors. Okay, so moving on, most states have a master jury list or a jury wheel, which includes all eligible juries within each jurisdiction, and they kind of, most states, I think, have shifted towards a random selection of jurors. Some of this is kind of the more common, but the key man system does exist where the leaders would select the juries. Okay, particular to Indiana, we have the statewide jury pool project, and this project is designed to increase the jury pool in Indiana to make it more inclusive. So as you can see, based on this little graphic down here, our jury pool used to look like this, and now our jury pool looks like this. So in the past in Indiana, they were only using voter registration lists, and now they are Indiana Supreme Court, the Judicial Center, the Jury Committee, the Department of Revenue for the state, and the Bureau of Motor Vehicles have partnered to create a more comprehensive jury list. So this project in Indiana was started in 2006, and it has gotten rewards from the ACLU of Indiana and the American Judicature Society. So it's kind of actually cutting edge way to increase jury pools and diversity that Indiana is using right now. So a lot of states juries a lot of professions in states have exemptions. So people who are either perform an occupation that's a service to society, or those who are directly involved in criminal justice receive an exemption from sitting on jury service. So you can see like political office holders in 16 states have an exemption. Police officers have one in 12 states. There's other ones, okay, like clergy and teachers and accountants. So not everyone in a state is eligible to be in the jury pool. So once we have our list, a veneer is created. The veneer is when the individuals actually show up for jury duty in the courthouse. So that's the group. They're the jury pool. They're called the veneer. Then the veneer is broken into jury panels, and each panel reports to a specific courtroom. Once those jurors are in the courtroom, voir dire occurs. Voir dire is Latin for to see, to speak, and these prospective jurors go under oath, and then they are questioned. The most common way is that judges will ask the questions, but lawyers can ask the judge to ask certain types of questions. The goal here is to root out biased jurors, kind of by engaging in voir dire. The ways that we root out those biased jurors are by challenges for cause and peremptory challenges. Challenges for cause are because the juror cannot be fair because of bias. Maybe they know somebody in the trial or in the courthouse. Peremptory challenges, jurors, this is the move to exclude jurors who are not favorable to your side. So maybe the defense team doesn't want to have any they don't want any engineers, so they might use a peremptory challenges to strike the engineer off the panel. Okay, so it's completely within discretion. Sometimes people hire jury consultants to help them. That's really, in criminal cases, that's really only the high-profile cases. Now, so that's how we get them. After the voir dire, we get to the 12-person panel, and then we keep 2 alternates usually, and then the trial starts. So throughout time, we've seen quite a few different reforms. Now we have moved from jurors not being allowed to take notes to now they are almost always allowed to take notes during the trial. Jurors can ask questions. The questions are submitted to the judge, and then the judge decides whether or not the question moves forward or not. But this is important to let the people who are deciding the facts to maybe ask for some clarity on an issue if it's unclear to them. We get written copies of the jury instructions for each juror. The thought is that it's delivered orally by the judge on the record, and then they have a written copy that they can go look back at, and this is supposed to help improve the deliberations. Another reform are that jurors can have a trial notebook. That trial notebook would contain the jury list, a witness list with photographs, so a picture of the witnesses so that the jury can remember. This might help some people kind of jog their memory about who said what. And then we also let them have key documents and exhibits, so maybe photographs or diagrams or things that were brought into evidence. This was done to help improve deliberation, make it more quicker, but also more effective, more fair. As you can see, almost 70% of states let jurors take notes. So we see these kind of reforms. It's likely that these reforms will continue to go up. Some of these are fairly new. Now, again, how these reforms are implemented varies greatly. So our last topic for this chapter is jury nullification. So this is the concept that jurors are the conscience of their communities. They are a subset of their communities, and they're supposed to represent the values of their community. So a jury can refuse to apply the law. So these are cases where the prosecutor proves each and every element of the case beyond a reasonable doubt, but the jury decides for some reason not to apply the law because it is unfair in their eyes. And once the jury issues that final decision, jeopardy attaches, so they cannot be retried. And this means that the defendant gets acquitted. This is usually used for controversial or unpopular laws. Judges don't inform jurors about this possibility, and if a juror were to ask about it during voir dire, it's likely that a judge would remove that juror.